Okay, we have 3 cases on the docket this afternoon. We're going to take them in the order that they appear, and we'll probably go straight through without a break. For the appellants, when you get up, if you want to save time for rebuttal, let me know. But you will ultimately be responsible for the clock in front of you. Are both sides ready in the first case? You may proceed.
Madam Clerk, I'd like to reserve 4 minutes, please. May it please the Court, my name is Edward Quinton. I represent the 3 appellants in this case. The appellants in this case are Sterling franchised truck dealers. We are before this Court on appeal of the final order of the Department of Motor Vehicles, in which the Department dismissed the complaints that were filed on the basis that the Department did not have authority to review the challenged action under Florida Statute 320.641. In short, what we're asking the Court...
How about that? Can the Florida DMV tell a national truck manufacturer it has to stay in business?
No, it cannot tell the truck manufacturer it has to stay in business. That's not what this case is about. The Dealer Protection Act, which this is a part of, what it provides, and under 320.699, what it provides the Department with authority to do is if a motor vehicle dealer is directly and adversely impacted by an action of the manufacturer, then the dealer has the opportunity to ask the Department to make a declaration of its rights. So what the Department can do is make a declaration of its rights. In this particular case, we're asking under 320.641 to make a declaration that the challenged action, which is a discontinuation of manufacture and sale of new trucks to the dealers, the challenged action is a discontinuation of the franchise agreement, or alternatively a modification of the franchise agreement, and such discontinuation or modification is unfair and prohibited. That's the relief that we're provided.
This is really a matter of semantics, because in dismissing the case, that's essentially what the Department has said, is that this was not a de facto discontinuation of a franchise agreement, and therefore we have nothing further to say.
Absolutely not, Judge. I think if you look at the ALJ's order, and I went through it page by page, line by line, he ultimately gets to a point where he says that this right to go out of business is such a fundamental right that there must be clearer, what he says is clear manifestation of intent, that what the Florida legislature meant was in 320.641, the discontinuation or modification of the franchise agreement provision, there must be something in there that in effect tells us that the challenged action of going out of business may subject you to a determination of whether that is an unfair or prohibited discontinuation of a franchise agreement or an unfair modification.
Well, what would happen if Daimler, the only truck that they were making were these Sterling trucks, and they said we're no longer going to make them?
Well, if they said we're no longer going to make this Sterling truck, and if the dealer felt that that directly and adversely impacted the dealer, then the dealer can come to the Department under 320.699 and ask for a declaration of its rights.
But that basically goes back to Judge Benton's question. Here, I think you can make the argument that because they're still producing trucks, that they were continuing business. Does the Department of Motor Vehicles have the ability to tell a business they can't go out of business?
No, not tell them they can't. It's really important that that's not the issue in this case. We're not suggesting that the statute gives the Department the opportunity or the right to tell Daimler they can't go out of business. They can go out of business, and they did go out of business. Sterling can go out of business, and they did go out of business. The key for the dealer under this Dealer Protection Act is to be able to get an adjudication or a determination of their rights, whether or not going out of business is actually a discontinuation of the franchise agreement or modification, and if it is, there's another step. Is it unfair or prohibited? And if you look at 320.
Are you alleging some unfairness?
Absolutely, Judge.
But didn't you agree that in the agreement that Sterling could, that Sterling could cease to manufacture trucks and you would have no right to pursue that?
No, that's incorrect. The provision you're referring to, Judge, is the provision that in effect says Daimler Sterling. Sterling reserves the right to discontinue manufacture and sale of trucks to the dealer. Our position, if we'd gotten a hearing, we're just asking for a hearing at this point because the department said they don't have authority. We're asking for this court to say they have authority. Our position, Judge, you look at the franchise agreement, that provision is in there, but you also look at the severability provision in the same franchise agreement. And why is that in there? Because 320.63, another part of the Dealer Protection Act, says, the state of Florida, the department says, if you want to be a manufacturer in the state of Florida and get a license, you have to put in your franchise agreement a provision that says nothing in this franchise agreement violates the law, and in particular, the Dealer Protection Act.
So you're saying that provision that's in the contract violates the Dealer Protection Act?
Absolutely. And that's, if we had gotten a hearing, but we didn't because the DMV said we don't have authority.
Did you allege the illegality of that provision in your part?
In our complaint, we allege that there was, what the challenged action was, discontinuation of manufacture and sale of Sterling trucks. We allege that that's a discontinuation of our franchise agreement or alternatively a modification, and that such discontinuation or modification is unfair and prohibited. And we set forth the letters that...
I understand.
So
did you allege that that provision that we're talking about was illegal under the statute? Did you use
that was
those
asserted in the department proceedings, yes, sir.
in the complaint?
Not in our complaint. That's there. We did not cite, I'm just trying to understand your question. Did we cite 320.63?
And say that this provision in the contract was illegal?
Yes. In our response to their motion to dismiss, the case was determined on a motion to dismiss. In our response to their motion to dismiss, we put forth this argument. Yes, sir.
Well, now you haven't alleged, I mean, you don't have any doubt, I guess, do you, that the decision by Sterling to discontinue manufacturing trucks is a legitimate thing. It wasn't a pretext, was it? I mean,
absolutely not, Judge.
You haven't alleged that, though. In other words, what I'm thinking of is let's say a company decides they don't want to market Oldsmobiles anymore because they aren't selling.
Good example.
Not exactly a hypothetical, is it?
Yes.
But what we're going to do is we're going to do that because we want to cut out all the Oldsmobile dealerships. They're just dead weight around our neck. So we're going to continue to make Oldsmobiles. We're going to call them Pontiacs now because we can cut our dealership network 5 times over by doing that. And so we use this as a device then to cancel franchise agreements. If that happened here, that would really concern me. But it doesn't seem to be you've alleged anything close to that.
But Your Honor, at the point that we were at in this case, we filed a complaint identifying the actions that were done and the statute we felt was violated. So the next step is you have a hearing, you take discovery, and you present a hearing. We believe that part of what, but we have to discover in this, we believe that part of what Sterling is doing is exactly that. They're going to potentially rebadge Sterling trucks under another line make so they have a smaller dealer body. We think that that would violate 320.641 because there's a good faith requirement, there's a good cause requirement.
That goes back to my question earlier. I mean, the reason you were arguing when you have a case is that these people were still producing some trucks. If they weren't producing a truck, it would not have been a subterfuge.
It would have been a different factual case, certainly. But it still doesn't mean that we wouldn't pursue that this was an unfair or prohibited discontinuation of our franchise agreement. We never got a chance to lay this out because the court, the DMV said we don't have authority. No one ever got into the issues that you all are raising.
So we don't know, or did you allege that Daimler also owns or controls the manufacturer of Freightliner and Western Star trucks?
It's in the record. Is it in our complaint? No, we did not make that allegation in our complaint because I don't believe that the requirements, the pleading requirements for this complaint would require us to lay that kind of a fact out in the complaint. Certainly when we got into the hearing, got into discovery, those are the facts that we would look into. We never got a chance to do that. The DMV said we don't have any authority because there's this fundamental right to go out of business. We never got an opportunity. This is
The ALJ and then the department articulated the basis for their decision. They were apparently under the impression that the entity here was going out of business. But now we're being told that there were other lines. You say somewhere in the record there's some indication that they build other trucks.
correct. Well, let me. I'm
So,
sorry.
quite properly, the ALJ and the department looked to the pleadings, and now you're just sort of giving us general information.
They did not look to the pleadings. If you look at our pleading, we don't plead that they're going out of business. How did the ALJ come up with the fact that they're going out of business? They don't assert that they're going out of business. This is one of our two primary points on the authority to review.
Well, you said you attached the letters. The letters said they were no longer going to make Sterling trucks and sell you Sterling trucks.
Judge, if you read the letter, specifically what they say in the letter is we're not going out of business. They say we're not going out of business because we're going to continue to do warranty service for these trucks. We're going to continue to sell new parts for these trucks. They specifically and expressly say they're not going out of business. We never allege that they're going out of business. What we allege, the challenged action that we are asking our day of review on is whether or not discontinuing the manufacture and sale of trucks to us is in fact a discontinuation or modification of our franchise agreement, and if so, is it unfair and prohibited under the criteria set forth in the statute?
So you're arguing it's a factual issue whether it was a discontinuance of the franchise agreement.
That's an issue of fact that we should have been able to present at a hearing. We never got to a hearing because they said they don't have authority. Why did they say they don't have authority? Because they said that there is a fundamental right to go out of business. There's no fundamental right to go out of business, certainly not identified in the two Supreme Court cases they
Let's
assert.
put aside the fundamental right to go out of business. The question comes down to, does the statute contemplate that the Department of Motor Vehicles has the right to preclude somebody from stopping to manufacture a product?
No, Judge. Again, Judge Benton asked that same question. That's not the relief we're seeking. If I make anything...
Tell me the relief you're seeking.
Okay.
You're seeking a declaration that they acted unfairly under the franchise.
What we are seeking is, we have the challenged action is their not going out of business, discontinuation of manufacturing trucks and selling them to the dealers. They say in their letters they're going to continue in business, but they're only going to be focusing on service, warranty, and parts.
And what's the remedy you can get?
So
what is the remedy you can get if you win?
So what we get is we get a declaration from the department saying that their actions are unfair and prohibited under the statute. This is the whole umbrella of the legislative...
Where does that take you? Help me.
Where does that take me? It gives us the opportunity, because the department cannot award damages, it gives us the opportunity, if we succeed, the department might say it's not unfair. It's a fair discontinuation. It's a fair modification. We may not win that, but we want a right to a review, which we're entitled to. So where does it get us? One place it gets, if we do succeed, if the department says, yes, this was an unfair, under the criteria of the statute, they go through that, and they say, yes, this was an unfair discontinuation. Why is this statute even there? It's because of the unequal bargaining power, the harsh treatment that manufacturers have inflicted on dealers. The dealers have an opportunity to go in for a review. Our clients have spent millions upon millions of dollars building facilities required by Sterling, and now they want to at least have a right to review under the Dealer Protection Act. So, Judge Wolf, where does that go for us? If we ultimately prevail, and the department says, yes, it's an unfair discontinuation or an unfair modification, we would have the right to go into court and use that to recover our damages. Never is anybody going to seek to make them go back into business.
What about this Bert Smith case? How do you see that as being different? The automobile case or it seems to me it's very close.
The facts of that case are different, because what was happening there in the Oldsmobile had what they called a phase-out. And the phase-out was we're going to continue for a while, and then we're going to phase out. And I believe if you read that case, part of the court's decision was that they were still phasing out. the dealer was still getting vehicles. The dealer was still doing service. The dealer was still selling parts. So there was a phase out. There was no actual discontinuation or termination at
By
that
your
time.
argument, they would have no right even to phase out, wouldn't they?
Well, it would be, I think that's part of the review we're asking for. You know, are they phasing out? Are they still in business?
Are you saying essentially, I mean, I think it, probably everybody in the room could agree that if Sterling goes out of business, decides that it can no longer sustain its business and can no longer produce trucks, that will have the effect of discontinuing the franchise agreement. But is that really the same thing as a cancellation? I mean, there are a lot of reasons why, there are a lot of things that might have the effect of a cancellation. What if they went bankrupt? That would have the effect of a cancellation. Are you not confusing the effect with the intent to cancel an agreement?
No, I think what the statute does, it goes right to that. So in other words, they make an announcement that they're no longer going to manufacture trucks and sell them to the dealer. Well, what is the basis of that? Is it because they're losing hundreds of millions of dollars? Well, then if you go to the review, one of the criterion is good cause. Well, that sounds like good cause. That would be probably good cause if they're losing all that money. So then the department's going to say, theoretically, that's not an unfair discontinuation because they're losing millions of dollars. So it's not unfair. So, you know, go on your way. But if what they decide to do is give these trucks to Freightliner dealers, that Sterling is making a lot of money, but they feel, the guys over in Germany from Daimler feel like they can make more money if they get rid of these Sterling guys who've built these huge, huge facilities and give those models to the Freightliner guys. They
Got 4 minutes.
Okay. I'd like to reserve. Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Dean Bunch. I'm here on behalf of Sterling Trucks with my associate, Jenny Goulday. Sterling Trucks and these three dealers have a dealer agreement. It's very unambiguous. It says we have the right to stop manufacturing trucks at any time. The dealers in this case contend that before a manufacturer can exercise that option, one that they agreed to, and know whether or not they're going to have to pay treble damages and attorney's fees. And one of Your Honors asked, well, what do you get with it? Well, he gets a department, and then he gets to go to court, and the 11th Circuit has ruled that the treble damages are automatic, not discretionary, but automatic. So using my good friend Mr. Quinton's argument, before a manufacturer goes out of business, they say, well, better go down to Florida and put on our case. He would have us put on our case that we're losing enough money that the department comes to the conclusion, yes.
Well, help me a second. You just said your people are going out of business, effectively. I mean, that was the analogy you made.
I'm sorry, I didn't hear you.
You said somebody before they go out of business has to come down to Florida and get a determination that it's appropriate. So you just said effectively that your client was going out of business here. Part of your argument that I don't understand, and you have to explain to me, is how do you argue that this is not a discontinuance of the franchise agreement? Or at least that doesn't become a question of fact. If I have a franchise agreement to sell somebody's trucks and repair and do something else, probably 80 or 90% of the reason for entering into it is that I could sell the trucks, not that I can repair them, not that I can sell the parts. I mean, I'm picking a figure out of the air. So when you come in and say, we are no longer going to provide you new parts to sell or new trucks to sell, why doesn't it at least become a question of fact whether that is a discontinuance of the franchise agreement?
And I misspoke, Your Honor, with respect to going out of business. We're going out of the business of manufacturing new trucks.
Okay, well,
we're not going out of the business of what the laws require us to continue to provide the parts and
I jumped on it.
Right.
But that's still the question is, even if you hadn't used that terminology,
right,
why doesn't it become a question of fact whether that is a discontinuance of the franchise agreement?
Well, now you say that you are going out of the business of manufacturing new trucks.
We're ceasing the manufacture of new trucks. We announced that we were ceasing the manufacture of new trucks in November 2008. We did, in fact, cease the manufacture of new trucks in 2009. March of 2009, Mr. Quinton did not allege that that was untrue, that we were not doing it, that all this was just a ruse.
Well, now, the Sterling truck has some relationship to Daimler.
there are three different line makes owned by Daimler Trucks, just like General Motors has Chevrolet and Cadillac and GMC truck and so forth. There are three different line makes. Chapter 320 is very clear that these cases are dealt with on a line make by line make basis. Doesn't matter who owns the company, but in fact, Daimler Truck has three different heavy truck brands: Freightliner, Western Star, and Sterling. The Sterling line make ceased to be manufactured.
Okay, now, before Judge Benton dragged you over here, one of your arguments that you make is that this is not a discontinuance of the franchise agreement because you can still repair trucks. You can still do this. When I have a franchise agreement with an automobile dealer to sell their vehicles, why doesn't it become a question of fact that the sale of the vehicle is so much of the contract that if you take that part of the franchise away from me, it is effectively a discontinuance of the franchise agreement?
Because 320-641 says a termination or modification of the franchise agreement. It's not a modification of the franchise agreement because the franchise agreement gives us the right to cease manufacture of the trucks at any time. So it's not a manufacture. It's not a modification of the franchise agreement. It's not a termination of the franchise agreement because the franchise agreement lives on. The dealers have the rights under the franchise agreement.
Why doesn't that become a question of fact?
No.
That you have just given them a worthless piece of paper?
No, it does not. And let me explain to you why. If you look on page 6 of his brief, what does Mr. Quinton say the disputed facts are? He doesn't say the disputed facts are whether, in fact, we have ceased manufacturing trucks. What he says the disputed facts are, and what he would like to have a hearing about and to put on evidence is whether, quote, whether Sterling was losing substantial amounts of money. The question is whether it was fair or unfair. And we don't get there unless there is something in the statute which specifically provides and specifically gives the department the authority to make that determination. And there isn't. Now, there is no indication in 320 that the department has any authority whatsoever to determine that. 320-641, which is the termination section, has a lot of things and limits in a lot of ways a manufacturer's right to put things in dealer agreements. One of the most important things is the term of the dealer agreement. And most contracts that all of us have seen, contracts have terms. They expire in 10 years or whenever they expire. Well, the legislature has specifically provided that in 320-641, in words of one syllable, if you want to non-renew a dealer agreement, in other words, if it says it expires in 5 years, if you want to non-renew it, you have to have the same grounds to do that as you would to terminate it. So
well, let's go back. Let's go to the General Motors and Oldsmobile.
Okay.
Can I go to an Oldsmobile dealer if I'm General Motors saying, okay, you can still sell spare parts, but that is not the termination of the franchise agreement? I mean, I'm getting a little bit of, I'm having trouble with that portion. I understand your argument that they can't oversee, the department can't oversee you stopping business. That portion of your argument I understand.
Right.
But I'm really having trouble saying that this is not a discontinuance or a termination of a franchise.
It's not, because the legislature knows how to restrict very specifically what goes into a franchise agreement and what does not. And they prove that by doing it in the example I've given you, that dealer agreements don't have terms. In essence, they're in perpetuity because you have to have the same grounds to non-renew as you do to terminate. If they had wanted to say the cessation of manufacture meant something, they could have said it in 2008, and they didn't. Now, how do we know they could have? Because they did in 2009. The law that's cited in our brief, 2009-93, they specifically used those words, cessation of manufacture, and they gave the dealers rights with respect to the cessation of manufacture. This happened prior to that legislation being adopted. So there's no question, if the legislature had intended to do what Mr. Quinton says and had intended to say that a cessation of manufacture could, under certain circumstances, amount to a modification or termination of a dealer agreement, they could have done it because they used that language. They gave a different remedy, but they used that language the very next year. So
Would you concede that there are some situations in which a decision to stop manufacturing vehicles, if it in fact is a pretext for something else, could in fact be a termination?
I suppose that's a possibility, but it certainly wasn't alleged here.
If it was done basically to shift the name, to shift one manufacturing facility and one group of employees into another line make for the purpose of reducing the obligations that the company has to dealers, maybe in that situation it could be. And I cited the Hunt truck sales case in our brief from the Department of Motor Vehicles, and what it held was that these cases are decided on a line make basis, and that manufacturers have the right to that it matters. What matters is what badge is on the car or the truck. But there was no allegation of any of that in this case. That's your real problem, isn't it? Is that the complaint says it's just as a matter of, if you take a matter of form over substance, this is essentially a cancellation of the franchise agreement,
Right.
which is all it says.
Right.
But you would concede there are some circumstances. I mean, if for example, let's suppose the facts are that Daimler was looking at its accounting records one day and discovered that one of the real problems is that it way too many Sterling dealers. And it's kind of, I don't know much about this business, but I understand that's how General Motors got in trouble. They had way too many dealers. One of the things, one of many. And decided, well, the way we're going to fix this is we're going to just stop making Sterling trucks. We'll make exactly the same truck. We'll call it a Freightliner, Western Star. We'll collapse all that into Sterling. And in the end, what we'll end up doing is cutting about 500 dealers nationwide and we'll save a lot of money. That wouldn't be right.
Your Honor, I should agree with you. Obviously, perhaps in the context of this case, I will tell you, based on my understanding of the law, the essential element is what the badge is on the vehicle. And as long as the trucks can be made hither or yon, and as long as they have that badge on them as a Sterling
so
or whatever.
So they can stop making Sterlings for whatever reason, in your view?
They could. There was no allegation of that in this case, and they stopped manufacturing the trucks. In the record in this case, it says we manufacture the trucks, and I forget where it is. I think it's in Canada. That is going to come to an end in March 2009. It did. There's no allegation to the contrary. The issue, what Mr. Quinton wants, is a fairness hearing, and as to why it was we did that. And if we lose, if the department found that we didn't have just cause to do that, then we would owe him automatically, under the Mike Smith case, treble damage and attorney's fees.
If he could amend his complaint to essentially allege, I'm not suggesting he can do this, but if he could amend his complaint to allege that this was just a device to rid Daimler of some of its Sterling dealers, this decision to quit making Sterling trucks, would you concede that he has a right to a hearing now? I mean, I'm asking the question because
I will tell you what my understanding of the law is, and my understanding of the law is that as long as as long as the trucks are badged under a different badge, that he would not have that right. But that, as you say, that's
So you believe, so in your view, the manufacturer could have given the notice it gave, cut loose all these dealers, except insofar as they would still be authorized to sell parts and perform service, and enter into contracts with a whole other new network of dealers and sell the exact same trucks, except with a different label, perhaps Freightliner or Western Star or Daimler,
or great trucks or some new name. Yeah, yes, that is my understanding. That is not the issue here, of course, but I'm giving you my understanding of the law as it presently exists.
But your understanding is that even in those circumstances, they would not be entitled to a fairness hearing. Is that your position?
If there was no allegation in this case that was going on, if the allegation was that they were not ceasing to manufacture trucks, if they were not ceasing to manufacture the trucks, then I suppose theoretically it's hard for me to deal with because I don't know what the allegation would say, but perhaps there might be some allegation of that. But there was no such allegation here. There was no request on the motion to dismiss. Wait a minute, Judge. We need to amend our complaint. There was no request to amend or anything like that. There was the allegation that Mr. Quinton was made and the hearing that he wanted was very clear then, and it was very clear when he wrote his brief. He wants to be able to come in and show that, in his view, there was not evidence that we were not losing enough money, that it was somehow unfair that we came to the decision we made. And that's the issue that the department said the legislature has not given us the right to decide.
I guess two questions. Number one, was there any attempt, because I have some of the same compunctions about the complaint here that Judge Palmetto does, to amend the complaint, or was there a procedure that would have allowed them to amend their complaint?
There was no request to amend the complaint. That we had a complaint, we had a motion to dismiss, we had at length oral argument. There was never a request to amend the complaint either before the ALJ or before the department. There was no oh gee whiz, if I'd had a chance to allege those facts, things would have turned out differently.
What were the grounds for the motion to dismiss? Was the motion based on the view that there's been a failure to allege unfairness?
The motion was based upon the fact that that 320.641 did not grant to the department the right to review a decision to cease manufacture of vehicles, that was not a right that the department had, and they agreed with that contention.
Fair or unfair?
Fair or unfair. You don't get to the fairness or unfairness until you make the determination, does the department have the right to review that decision? And that was the basis of the motion to dismiss. You simply don't have the authority to review that decision.
Okay, my understanding is, that is a decision of law, no disputed facts. You just decided to discontinue, that's a non-reviewable decision.
There were no disputed facts with respect to whether or not the department had jurisdiction. In other words, there were no disputed facts that Mr. Clinton alleged with respect to that threshold issue. There were disputed facts with respect to, well, if you let me prove my case, I'll perhaps be able to show that they weren't losing enough money to cease manufacture and those other things. As to the fairness or unfairness, there could always be disputed fact, but not on the threshold issue.
Did the department specifically, and I should go back to the order, and I'm sorry I'm not, but did they ever specifically rule on the legality of the contractual provision that you're partially relying on? They never ruled, and they did not rule on. I don't remember Mr. Quinton, and Mr. Quinton will correct me, I'm sure. I don't remember him specifically saying that this provision of the dealer agreement is in violation of 320.63 or any other provision of the law. Now, perhaps he did. I just don't recall it. But I don't believe that was before the agency. I don't believe they made a specific ruling on that issue.
So in paragraph 9B, there was some contention in the brief to that effect.
There was a contention in the brief on appeal to that effect. And again, I apologize in advance to my good friend, Mr. Quinton, if I'm misstating. I'm glad he'll have the opportunity to get back up here and correct me if I'm wrong.
I think he might have said today that that position was advanced in opposition to the motion to dismiss.
But let us assume that it was. The look at 320.641. The statute very specifically governs certain things that cannot be in dealer agreements or that are overridden if they are. For example, if a dealer agreement says it has a 5-year term, the legislature had no problem in saying it doesn't matter what the term is. You have to have the same right. You have to have the same cause to non-renew a dealer agreement that you do to terminate a dealer agreement. And in 2009, they had no problem in saying, by the way, manufacturers, if you cease manufacturing using exactly those terms, here's the penalty. Here's what you have to do. Here's what you have to pay the dealers. They had no problem in doing that. So even if that had been alleged, I would submit to your honors that when you look at the statute over here, and you look at the very specific things that it regulates, prohibits, and restricts, and then you look at the dealer agreement over here, the statute simply did not limit, restrict, or penalize a manufacturer from a decision to elect, from the decision to cease manufacturing its product, and did not give the department the authority to conduct a hearing to determine whether that decision was fair or unfair. That's what the ALJ ruled, and that's what the department ruled. And the department, having ruled on that with respect to its own jurisdiction.
The statute prohibits the failure to provide a supply of motor vehicles by series in reasonable quantities and so forth.
Reasonable quantities, that's right.
All right, so that is something that the right to fail to provide could not be reserved in a franchise agreement.
Right. You can't say, I reserve the right to give you guys over here, to give the guys in South Florida a reasonable supply, an adequate supply, but the guys in North Florida, you don't get it. Or you have to give your vehicles to everybody. You have to give a reasonable supply of vehicles to everybody. But that doesn't say you can't stop manufacturing them altogether. We could not have entered into a discriminatory.
And yet if you do stop manufacturing, you obviously soon thereafter will fail to provide a supply.
Well, looking at the totality of the statute and the other section which says that allocation systems have to be fair, reasonable, and equitable, I think and there's also language in the subsection you read of 32064 and there's 35 prohibitions in it that deal with the fact that if you advertise a vehicle for sale, that it's got to be available in reasonable quantities. And in this case, we notified the dealers and the public at the same time that we were going to cease manufacture of these trucks. So I don't think you can read those sections of 32064 fairly to prohibit or to restrict or to penalize a manufacturer from making the decision we're going to cease manufacture of the trucks as long as they do it in a non-discriminatory way. In other words, you couldn't say, oh, well, I'm only going to make enough trucks to supply California and I'm not going to supply Florida anymore. But that was not the case. It was totally uniform and throughout the whole United States. And I believe my time is up.
I think so. Thank you.
Thank you, Your Honors.
I did want to.
Let me go back to the issue of the contractual provision. And I'm sorry, but I tend to do that sometimes when I ask a question when people come up. You said you argued that that provision in the contract was illegal and was contradictory to the statute. Why isn't that a question of law, and why shouldn't we give deference to the department in their interpretation of their jurisdiction?
First of all, that it is a partial question of law. You have to understand what's happening factually. But going back to the department, every one of you have asked critical questions about the merits of this case, such as, the obligation to deliver vehicles. How does that play out with the language in their contract or the requirement that there be a severability clause? These are all the elements that we should have been able to bring forward to the department. None of this was heard by the department because what the ALJ said is they don't have authority. We can't even get into any of these things. That was that problem. We were never able to have a hearing in any way. The legal issues weren't addressed, nor were the factual issues addressed. So we're here to asking you to say that there is authority, so that it should go back and they should go through these exact questions that you have asked.
Okay, is part of your argument here that you should have an opportunity to amend, or has that argument ever been made?
Well, part of the issue was we filed a complaint under the statute and alleged, the discontinuation of the franchise agreement, modification of the franchise agreement, and that it was unfair and prohibited under the elements of the 320.641. Did we get into all these factual nuances in our allegations of our complaint? No, because that was the part of the hearing. You take discovery. We deposed their person and asked these questions. But that's the whole purpose of the Dealer Protection Act, to protect the dealer who they have required to make millions of dollars of investment. And so if they make a decision like that, at least we get a review. We may not win.
So you allege in conclusory terms unfair or prohibited.
We go through the steps that it was not. We say it was not in good faith. It was not for good cause. And these are the factual elements of whether or not are they just going to rebadge. If they do, that's not good faith, and we allege that they did not, they terminated in bad faith.
Or then the motion to dismiss doesn't say you failed to allege with particularity.
Exactly. And I need, Judge Wolf, you had asked a question, this goes to your question too, Judge Benton. If you read their motion to dismiss, their motion to dismiss says one thing. We should dismiss the case because we're not going out of business. This statute is about going out of business. We're not going out of business. That's what they allege in their motion to dismiss. Since we're not going out of business because we're going to do parts and service, since we're not going out of business, there is no discontinuation of a franchise agreement if we're not going out of business. The ALJ came out of left field and said, wait a minute, there's no authority. I'm just on page 18 of his recommended order. What he says is there's no, the department doesn't have authority to review this decision. The decision that we challenged, the challenged action, is their decision to discontinue the manufacture and sale of new trucks to the dealers. And they said we don't even have authority. So they didn't get into any of these questions. We didn't have a chance to do any discovery on these issues that I raised. This is the whole purpose of the hearing, which we didn't get because they said no authority.
This was not a recommended order in the classical sense, right? It wasn't so styled.
No, in fact, it's titled, I believe it's titled Order Relinquishing Jurisdiction for Entry of Final Orders of Dismissal. It's relinquishing jurisdiction because the ALJ said, I don't have authority to even look at these things that you're raising or we've raised. That's what we're here for today. Give us the ability to go back and have a hearing which the Dealer Protection Act provides for us.
Are you aware of any similar litigation like this in Florida that's ongoing? It seems to me if your point is right, that the termination of a manufacturing business is ipso facto the termination of all the franchising agreements. If that's correct, it seems to me there would be dozens and dozens of lawsuits over Saturn dealerships and Saab dealerships and all these other companies that are no longer in existence.
Well, there was substantial litigation under Osmobile. You raised that one item. And there was substantial litigation over that it was, they called it a phase-out. Well, under the statute, we called it a discontinuation of the franchise agreement. In those cases, as far as I know, at least the ones in Florida, settled. So there's no final determination on
And the cases around the country seem to go both ways as I read them. I mean, there's a Virginia case that seems to go against you, and then some
in terms of what issue you say go against
the
me.
question of whether discontinuance.
Right, but we haven't gotten there yet. We want to go to the department and have our day, our review. We haven't even been able to put on our case yet because the ALJ says we don't have authority because he goes into this concept of this is a fundamental right.
Your time is run, but I got one more question because Judge Benton raised this and it kind of raised a red flag to me. This appears to be, this order is a kind of interesting animal under Chapter 120, relinquishing jurisdiction to enter the order. Because normally it would be a recommended order that you would have to file exceptions to the findings of fact and conclusions of law. Shouldn't you have been required to file those exceptions anyway?
We did file exceptions,
Okay.
and that was followed. But the issue was authority. Does the department have authority to hear our petitions? So, again, none of this went to the issues that you all have raised about the interplay of the statute, about the fact this is a Dealer Protection Act that the legislature has implemented to protect my clients who invest millions upon millions to at least have a review.
Okay.
Thank you.
very much.
Appreciate it. Thank you.